Hello and welcome to Liberty and Gun Rights Podcast. My name is James Moffett and I'll be your host. Today is Sunday, December the 22nd, 2024. Before you know it, it's going to be Christmas. So, one of the things that I want to show you, my listeners, is the new graphic that I had made up. Let me see if I can find it. Oh, there it is. And we'll make it larger. I'll turn on display capture so you can see it. There we go. Liberty and Gun Rights Podcast with James Moffett. Listen now. So that's the new logo, and I hope everybody likes it. I think it's a lot sharper than the old logo that I patched together a year and a half ago. Right? All right, so we'll turn that off. I just wanted to show that to you so that when you're on Apple Podcast or Spotify, you are looking for the American flag with gray or silver text. That is no more. So I wanted to kind of showcase it for you. So today is episode 38, and I'm going to be going over the updated list of proposed legislation for the 2025-2026 legislative session in Columbia, South Carolina. This was put together by Sheriff Scott, who is a board member on South Carolina Carry, as well as part owner of Sandhill Shooting Sports in Lugoff, South Carolina, up in the Midlands. If you're listening to this in the Midlands, Columbia area, Elgin, Lugoff, visit Sheriff Scott and the Sandhill Shooting Sports shooting range, and tell her I said howdy. All right. So, without further ado, I'm going to go over the Excel spreadsheet that Shara put together. Actually, I downloaded it from our Google Drive as an Excel spreadsheet. All right, here we go. So, I'm not going to read all of it to you. I'm just going to read you the bill numbers and where to find it. You can find all of these bills by going to https://www.scstatehouse.gov/session 126 _2025 2026 bills. All right, and I'm going to click on one of them so you'll see what you're going to see. All right, so I'm going to click on that, and that's going to bring up the South Carolina General Assembly. I don't know how much of this you're seeing. I know I need to make it a little smaller. I brought up my Edge web browser. And anyway, so you can see South Carolina General Assembly 126 session 2025-2026, and it shows you all the information that you need to know. You can actually download the bill in Microsoft Word format, and you can read everything in capital letters. It makes it a little bit more difficult to read. It was pre-filed on December the 5th, 2024 in the House, and it's referred to the Committee on Judiciary. And here's all the wonderful verbiage. Oh, actually, they've changed it to where it's not all in capital letters. It's a little easier to read. So the bill itself at the top is all in capital letters, but somebody was kind enough to make everything else in lowercase. So I'm duly impressed, right? But anyway, when you click on the link, that's what you're going to get. So let's go back to this. So H3032 is about disrupting a religious service or funeral. H3041, prohibition on assault weapons. HO 3056 is reckless endangerment. H3143 is on pardons. Now, these bills were searched using keywords weapon, handgun, rifle, long gun, and one other. I forget what all of them are, but Shara filtered all of these 560 bills down to the ones that we're interested in. Right? Thank you, Shara. 3143 is pardons. 3159 is law enforcement officers. 3180 is firearms. 3283 is CWP on college campuses. SC, Street Gang and Criminal Enterprise Prevention and Anti-Racketeering Act. Oh, so 3283 is about CWP on college campuses. 3520 is SC, Street Gang and Criminal Enterprise Prevention and Anti-Racketeering Act. 3587 is criminally negligent storage of firearms. 3596 is access to firearms by children. 3598, reporting information to SLED, firearms background checks. 3650 is discharging firearms into dwellings and other structures. 3658, Department of Consumer Affairs. So that's all House, and then I guess the S is Senate. S007 is red flag laws. Nationwide, the federal government, the DOJ, President Biden, whomever, they are pushing all states to enact red flag statutes, and if they do that, they get federal funding for the for that statute and the manpower and whatever it's going to cost to enforce that. So S007 is red flags. S018 is children's access to firearms. S053 is Compassionate Care Act. S076 is criminal gang and anti-racketeering, street gang and criminal enterprise prevention, which looks very similar to H3283. So we've got S115 is school safety. S117 is reckless endangerment. S129 is firearms storage agreements. S141 is firearm liability insurance. S149 is South Carolina Juvenile Justice Reform Act. So that's around 20 bills that South Carolina Carry, myself, and others are going to be following along with. Every time there's a change made to it, we'll get email notification of that, and you can too. All you have to do is go to the www.scstatehouse.gov and sign up. Give them an email address, create a password, and you can create your own filters and download whichever pre-filed bills that you would like to follow. And if they update a bill or there's a change to it, if it's amended, passed, sent to the governor for signature, whatever, you will get an email update telling you of such. All right, so I want to go to which one? Let's go look at the firearms. All right, this is H3180, Representative Gilliard, December the 5th, action description on journal page number, blah, blah, blah. To amend the South Carolina Code of Laws by amending section 1623-210 relating to definitions for purposes of this article or the article so as to define the terms assault weapon and high-capacity magazines, and to amend sections 1623-220 and 23-230 and 23240, all relating to the unlawful transportation, storing, keeping, or possessing and sale, rental, or giving away of machine guns, military firearms, sawed-off shotguns, or rifles, respectively, also as to include assault weapons and high-capacity magazines in the list of items banned by the provisions of the statutes. Assault weapon means a firearm with any of the following characteristics: all semi-automatic action centerfire rifles with a detachable magazine with a capacity of 21 or more rounds. So if you have a magazine that holds 30 rounds, guess what? It's going to be considered an assault weapon, and they want to ban it. All semi-automatic shotguns with a folding stock or a magazine capacity of more than 6 rounds or both. A shotgun with a folding stock or a magazine capacity of more than 6 rounds or both. A firearm which has been modified to be operable as an assault weapon as defined in this item, and any part or combination of parts designed or intended to convert a firearm into an assault weapon, including a detachable magazine with a capacity of 21 or more rounds, or any combination of parts from which an assault weapon may be readily assembled if those parts are in the possession or under the control of the same person. Assault weapon does not include weapons that do not use fixed cartridges, weapons that were in production prior to 1898, manually operated bolt-action weapons, lever-action weapons, slide-action weapons, single-shot weapons, multi-barrel weapons, revolving cylinder weapons, semi-automatic weapons for which there is no fixed magazine with capacity of 21 or more rounds available, semi-automatic weapons that use exclusively in-block clips, semi-automatic weapons in production prior to 1954, rimfire weapons that employ a tubular magazine, a firearm that uses 22 caliber rimfire ammunition, or an assault weapon which has been modified either to render it permanently inoperable or to permanently make it a device no longer defined as an assault weapon. High capacity magazine means a firearm magazine capable of holding more than 15 rounds of ammunition. So if you have a Smith & Wesson or a Glock or any modern firearm that has a magazine capable of holding more than 15 rounds of ammunition, it is considered a high capacity magazine and will be banned according to the statute. 1623-220 says it's unlawful for a person to transport from one place to another in the state of South Carolina, or for any railroad company, express company, or other common carrier, or any officer, agent, or employee of any of them, or other person acting in their behalf knowingly to ship or to transport from one place to another in this state a machine gun or firearms commonly known as machine gun, military firearm, sawed-off shotgun, assault weapon, or high-capacity magazines, except as provided in Section 1623-250 and 31-330. Person who violates the provision of this section upon conviction must be punished pursuant to Section 1623-260. All right, so I'm going to let you go read the rest of that for yourself. All right, let's see. That was prohibition on assault weapons. Reckless endangerment 3056 looks interesting. 3056. I gotta get to the right screen. Let's see. I'm hoping that y'all can see this. I may have to move it like that. All right, so this is H3056, reckless endangerment, to amend the South Carolina Code of Laws by adding Section 16365 so as to create the offense of reckless endangerment, to define necessary terms, and to provide a penalty for the offense. For the purpose of this section, the term firearm means a weapon that is designed to or readily may be converted to expel a projectile by the action of an explosive. Great bodily injury means bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or protracted loss of impairment or the function of a bodily member or organ. Motor vehicle means every vehicle which is self-propelled and every vehicle which is propelled by electric power obtained from overhead trolley wires but not operated on rails. Recklessly means the wanton and willful disregard of a substantial and unjustifiable risk of such a nature and degree that the disregard involves gross deviation from the standard of conduct a law-abiding person would observe. Reckless endangerment is more than an act after a mere failure to exercise due care. The violation of an applicable statute does not amount to reckless endangerment per se. Awareness of the unjustifiable risk and conscious disregard of the risk must be proven. A person commits the offense of reckless endangerment if the person engages in conduct that recklessly places another person in danger of death or great bodily injury, intentionally and recklessly discharges a firearm in a populated area or a residential area, or unlawfully discharges a firearm from a motor vehicle in a manner that is likely to produce death or great bodily injury to another person. A person who violates the provisions of this section is guilty of a felony and upon conviction must be fined not more than $15,000 or imprisoned not more than 15 years. Well, there you go. All right. Pardons, law enforcement officers, firearms. Let's go see what firearms says. That's H3180. I guess they're redefining firearms. I hope y'all are seeing this. All right, let's see. To amend the South Carolina Code of Laws by amending Section 1623.210 relating to definitions or purposes of the article so as to define the terms assault weapon and high-capacity magazines, and to amend Sections 1623.220, 23.230, and 23.240, all relating to the unlawful transportation, storing, keeping, or possession and sale, rental, or giving away of machine guns, military firearms, sawed-off shotguns, or rifles, respectively, all so as to include assault weapons and high-capacity magazines in the list of items banned by the provisions of the statutes. Well, this is starting to sound kind of redundant. I mean, it's defining assault weapons, high-capacity magazines, just like the other statute. So I'm not even going to read that. All right. Firearms. Here's an interesting one. 3283. CWP on college campuses. I think if I remember right, reading this, I liked what I saw in here. I don't know that it's going to pass, though. Be enacted by the General Assembly of the state. Let's see. To amend the South Carolina Code of Laws by amending Section 23.420 relating to possession of firearms on school property and concealed weapons so as to delete the restrictions placed on holders of concealed weapons permits on carrying firearms on post-secondary school properties, and to make technical changes, and by amending Section 2320, that's 162320, relating to unlawful carrying of handguns and exceptions so as to delete the restrictions placed on the carrying of weapons into college athletic events. So this bill, if passed, will remove some of the restrictions on those of us that have a concealed weapons permit in South Carolina, which is, I think, a good thing. One of the things that we need to do, we the people, need to pressure our lawmakers into reducing the locations that are prohibited for those of us that have gone through the FBI background check, have been fingerprinted, and are known to be lawful, law-abiding citizens. All right, so it is unlawful for a person to possess a firearm on any premises or property owned, operated, or controlled by a private or public school, college, university, technical college, or post-secondary institution, or in any publicly owned building without the express permission of the authorities in charge of the premises or property. The provisions this subsection related to any premises of property owned, operated, or controlled by a private or public school do not apply to when the firearm remains inside a attended or locked motor vehicle and is secured in a closed glove compartment, closed console, closed trunk, or in a closed container secured by an integral fastener and transported in the luggage compartment of the vehicle. The provisions contained in this subsection related to any premises or property owned, operated, or controlled by a college, university, technical college, or other post-secondary institution do not apply to a person who is authorized to carry a concealed weapon pursuant to Article 4, Chapter 31, Title 23. All right, so Section 2, Section 162320A of the South Carolina Code is amended to read, it is unlawful, whether or not the person has a concealed weapon permit, for anyone to carry about their person any handgun, whether concealed or not, unless otherwise specifically authorized by law, into a law enforcement, correctional, or detention facility. This is the whole list that we've been under for way too many years. Courthouse, courtroom, or other publicly owned building, whether owned by the state, a county, municipality, or other political subdivision, where court is held and during the time that court is in session, polling places on election days, office of or business meeting of the government body of a county, public school district, municipality, or special purpose district, school, athletic event not related to firearms, they struck out, or college, daycare facility or preschool facility, place where the carrying of firearms is prohibited by federal law, church or other established religious sanctuary unless express permission is given by the appropriate church official or governing body, hospital, medical clinic, doctor's office, or any other facility where medical services or procedures are performed unless expressly authorized by the appropriate entity. So I'll stop right there and say, if you go into CVS or Walgreens or Walmart or any business that is performing flu shots, any of these pharmacies that are giving you flu shots, that's considered a medical treatment, and that means that you cannot carry your firearm into that business. You may or may not know that. Residence or dwelling place of another person without the express permission of the owner or person in legal control of the possession of the residence or dwelling place as appropriate, or place clearly marked with a sign prohibiting the carrying of a concealed weapon on the premises in compliance with Section 2331-235. A person who violates provision of this item, whether the violation is willful or not, may be charged with a violation of Section 1611-620 and must not be charged with or penalized for a violation of this subsection. So, that's that. I apologize if I'm reading these a little too fast, but you know where to go to get to them. All right, let's see. Criminally negligent storage of firearms, H3587. Let's see. To amend the South Carolina Code of Laws by adding Section 1623-540 so as to create the offense of criminally negligent storage of a firearm, define necessary terms, and establish penalties for violations, among other things. For purposes of this section, child means a person younger than 18 years of age. Criminal negligence means the reckless disregard of the safety of others. Firearm has the same meaning provided in 1623-490. Immediate family means a person's spouse, parent, children, brothers, sisters, grandparents, grandchildren, and mothers-in-law, fathers-in-law, brothers-in-law, sister-in-law, sons-in-law, and daughters-in-law. Readily dischargeable firearm means a firearm that is loaded with ammunition, whether or not a round is in the chamber. Secure means to take steps that a reasonable person would take to prevent a child's access to a readily dischargeable firearm, including but not limited to placing a firearm in a locked container or temporarily rendering the firearm inoperable by a trigger, lock, or other means. Serious bodily injury, we already know what that is. A person commits an offense if a child gains access to a readily dischargeable firearm and the person with criminal negligence failed to secure the firearm or left the firearm in a manner that the person knew or should have known a child would be able to gain access to the firearm. It is an affirmative defense to prosecution under the section the child's access to the firearm was supervised by a person 18 years of age or older and was for hunting, sporting, or other lawful purposes, consisted of lawful defense by the child of people or property, or was gained as a result of an unlawful entry by any person. And it goes on and on. You can read more about that yourself. There are pictures I took yesterday. All right. So that was access to firearms by children, reporting information to SLED, firearms background checks, discharging firearms into dwellings, Department of Consumer Affairs, red flags. Let's go. That's always a hot topic, red flag laws. This act may be edited or cited as a Red Flags Act. Article 12, seizure of firearms and ammunition from a person posing a risk of imminent personal injury or self or others, to self or others. A solicitor, assistant solicitor, or two law enforcement officers may file a verified complaint with any probate court for issuance of a warrant to seize any firearms and ammunition of a person if the solicitor, assistant solicitor, or law enforcement officers have a probable cause to believe that the person poses a risk of imminent personal injury to himself or other individuals. The person possesses one or more firearms and the firearms are within or upon any person or property. Upon a receipt of an application that establishes the requisite grounds for the warrant as provided in Section 2331-1220, a judge may issue a warrant commanding a proper law enforcement officer to enter into or upon such property, search the person and the property, and take into the officer's custody any and all firearms and ammunition. The solicitor, assistant solicitor, or law enforcement officers must not file a complaint before conducting an independent. Let's read that again. The solicitor, assistant solicitor, or law enforcement officers must not file a complaint before conducting an independent investigation and determining that probable cause exists and that there is no reasonable alternative available to prevent that person from causing imminent personal injury to himself or to others with the firearms. 2321-1220, a warrant may be issued on an affidavit sworn to by the complainant or complainants before the judge in establishing the grounds for issuing the warrant, and the affidavit must be made part of the seizure file in determining whether grounds for the application exist. Whether there is a probable cause to believe the grounds exist, the judge shall consider recent threats or acts of violence by the person directed toward other persons, recent threats or acts of violence by the person directed towards himself, and recent acts of cruelty to animals by the person, including acts that violate Chapter 1, Title 47. In evaluating whether any recent threats or acts of violence constitute probable cause to believe that the person poses risk of imminent personal injury to himself or to others, the judge may consider other factors, including but not limited to the reckless use, display, or brandishing of a firearm by the person, a history of the use, attempted use, or threatened use of physical force by the person against another person, prior to involuntary confinement of the person in a hospital for persons with psychiatric disabilities, and the illegal use of controlled substances or abuse of alcohol by the person. If the judge is satisfied that the grounds for the application exist or that there is probable cause to believe that they exist, then the judge shall issue a warrant naming or describing the person or property to be searched. The warrant must be directed to a proper law enforcement officer, must state the grounds or probable cause for its issuance, and must command the law enforcement officer to search within a reasonable time the person or property named for any and all firearms and ammunition. A copy of the warrant must be given to the person named therein, together with a notice informing the person that the person has the right to a hearing pursuant to the section and the right to be represented by counsel at the hearing. So anyway, we'll just take due process and throw it out the window. Red flag laws are dangerous, and it gets citizens and law enforcement personnel killed unnecessarily. So we need to keep an eagle eye on this statute. Children's access to firearms, Compassionate Care Act, Criminal Gang, School Safety, Reckless Endangerment, Firearm Storage Agreements. All right, so I kind of highlighted the hot spots of that. I'm going to turn that off and minimize that. And so I would encourage you, if you didn't catch all of that, I know I was reading a little bit fast, to kind of limit the amount of time I was taking on that, because everybody can go to the scstatehouse.gov website and look them all up yourself. I just wanted to highlight them for you. All right, so what's next on the list? So what's next on the list? So we went over the updated list of pre-filed bills December the 5th in Columbia, South Carolina. In other news involving gun rights issues on the national front, Maine recently implemented a 72-hour waiting period for firearm purchases, which went into effect on August the 9th, 2024. This new law requires gun dealers and purchasers to wait 3 days before completing the sale of a firearm. However, this new waiting period has been met with significant opposition. A coalition of gun rights groups has filed a federal lawsuit challenging the law, arguing that it is unconstitutional. They believe that the waiting period infringes on the Second Amendment rights of law-abiding citizens. The lawsuit is still ongoing, and it remains to be seen how the courts will rule on this issue. The challenge highlights the ongoing debate between gun rights advocates and those pushing for stricter gun control measures. So, the next one, federal gun control rules. The Department of Justice introduced 2 new gun control rules under the Bipartisan Safer Communities Act, BSCA. These rules include the Firearm Handlers Rule, which imposes new requirements for firearm handling and storage. So, I'm going to show you this, and I need to make this smaller so that you can see it. There we go. Biden's DOJ introduces 2 new gun control rules. Now this is on gunrights.org. You can look this up yourself. The Department of Justice frames the rules as an outworking of the Bipartisan Safer Communities Act, which Biden signed in 2022. On December 16th, the Department of Justice, DOJ, released 2 new gun control rules under the label of Notice of Proposed Rulemaking. First of the NPRMs, called the Firearm Handlers Rule, states federal firearm licensees, FFLs, such as gun stores, be allowed to use a national instant criminal background check system to voluntarily conduct employment background checks for certain employees. Current NICS regulations prohibit FFLs from initiating background checks for any purpose other than the transfer of firearms. Under the Firearm Handlers NPRM, FFLs will be permitted to request NICS background checks for current or prospective employees who may handle firearms, ammunition, or related materials. The firearm handler's rule details the scope of employees eligible for background checks as well as new NICS statutes proposed for such checks. So that means if you go to PSA and you're applying for employment, the FFL can use the NICS, National Instant Criminal Background Check System, to check you and make sure that you are legal to handle firearms and ammunition and other accessories, I guess. The second NPRM, called Under 21 Rule, would codify enhanced NICS background check procedures by prospective firearm purchasers under 21 years of age, among other changes. Under the BSCA, NICS is required to conduct enhanced background checks for such under 21 purchasers by contacting certain state and local entities to determine if a juvenile record, such as a criminal conviction or mental health record, may disqualify the purchaser from purchasing a firearm. The FBI began performing those enhanced checks in late 2022 and has denied nearly 1,000 transactions solely because of enhanced outreach. Both of these proposed rules stem from the BSCA, which was renamed into law in 2022 following the Uvalde tragedy. However, gun rights supporters are saying none of these rules would have done anything to stop the horrific tragedy in 2022 or even prevented further Uvalde-style attacks in the future. Additionally, both of the proposed rules seek to change laws, making them unconstitutional, as this is a function of Congress. Such tests have caused multiple ATF rules to fail, as courts have decided that the agency exceeded its authority under the Administrative Procedures Act, also striking down Chevron deference, which formerly provided the regulatory agency final say on interpreting the meaning of a law. All right, that's gunrights.org where I got all that information from. All right, what's the next one? Trying to get my mouse back. Here we go. All right, the next one is concealed carry reciprocity. Discussions around concealed carry reciprocity continue, with advocates pushing for laws that would allow individuals with a concealed carry permit in one state to carry a concealed handgun in any other state that allows it. All right. Let's see. Trying to get past this garbage. Here we go. I'm getting there. So, what Donald Trump's concealed carry reciprocity means for gun rights. All right, let's kill that. Donald Trump promised to sign concealed carry reciprocity legislation if he won a second term in office. I think we would all like that. It's somewhat of a mind-boggling process to look at every state's gun laws before you travel to them. The policy would allow gun owners with a concealed carry permit from one state to legally carry their weapon in other states. Every state in the U.S. permits some form of concealed carry, but the regulations can vary widely. Some states do not require a permit to carry concealed weapons, while others demand permits stipulating certain conditions. States such as California and New York have particularly strict requirements. Trump spelled out his intention to change the law in 2023 speech, stating, "I will protect the right of self-defense everywhere it is under siege, and I will sign concealed carry reciprocity. Your Second Amendment does not end at the state line." Amen to that, brother. I appreciate that. Trump has long campaigned on a pro-gun platform, and all three times he has run for president, he has received an endorsement from the National Rifle Association Firearms Rights Lobby Group. The NRA and other pro Second Amendment groups support loosening concealed carry laws nationwide. I think we can support that, right? The NRA's official policy goes even further than Trump has promised, advocating for what they call constitutional carry, which would allow individuals who can carry legally possess guns to carry concealed firearms without needing a permit. The more lenient policy is also supported by other pro-gun groups, including the National Association for Gun Rights. Democrats and groups that advocate for gun control have long opposed concealed carry reciprocity. Well, there's no surprises there. So that is Newsweek.com. If you go to Newsweek.com, then you will see that. And what's the next one? State-specific legislation. Several states have enacted new gun laws. For example, California has introduced new measures aimed at reducing gun violence, including stricter requirements for firearm purchasers and expanded gun violence restraining orders. All right, so new gun laws take effect in 5 states today. Several states are ringing in the new year with increased gun control as mass shootings continue to devastate lives. Gun violence has become a major concern across the nation, with mass shootings in schools, nightclubs, and homes more prevalent. There were 656 mass shootings in 2023 versus 646 in 2022, according to the Gun Violence Archive, which defines a mass shooting as a single event in which 4 or more people, excluding the shooter, are shot or killed. Well, this news is a little bit old, actually, 2022 and 2023. So we'll skip past that one. Getting there. Come on. Where's my mouse? There it is. All right. Judicial rulings. Federal courts have recently struck down several state restrictions on gun ownership, citing the expanded interpretation of the Second Amendment by the U.S. Supreme Court. These rulings have challenged bans on assault weapons and concealed carry laws in states like California, Illinois, and Minnesota. Kansas legislation. Kansas received an F grade for its gun legislation, with calls for stronger laws to address gun violence, including universal background checks and measures to prevent gun trafficking. All right. So let me stop that. All right. Well, I hope that this has been somewhat informative. I hope that it helps to keep you clued in on pre-filed bills here in South Carolina and some of the things that are going on in the United States of America. This is going to be my last podcast episode before Christmas, which is, guess what, next week. Santa is going to come visit all the little boys and girls and put presents under the tree. And if they've been bad, then I guess they'll get coal or switches. I got some of those when I was younger, because I guess I was bad at some point. Anyway, let's hope that all the kiddos get good stuff, good presents under the tree, right? And I'm saying all of this because who knows who's lurking over the shoulder of mom or dad who are listening to this podcast or watching it, right? So anyway, having said all of that, I'm going to say this. Thank you for the privilege of your time. Our podcast is hosted on Amazon Music, iHeartRadio, and Spotify. And it's hosted on Apple Podcasts. I will tell you that Spotify is the only podcast hosting provider that you can watch the actual video. I think iHeartRadio and Apple Podcasts, all you're going to hear is the audio. You won't see my bright, shiny face. Be sure to share our podcast with your Second Amendment friends, family, and coworkers. You can contact me at Liberty Gun Rights Podcast at proton.me. That's Liberty Gun Rights Podcast at proton.me. Thank you for listening to today's episode. Merry Christmas and have a wonderful day. Bye bye.